When this case first landed in my courtroom, it looked simple. A woman walks in claiming someone she has known since high school stole from her. Not a stranger, not some random buyer from the internet. A person she trusted. And what was stolen? A car, not a luxury vehicle, not some brand new sports car. A worn-out 1996 Volkswagen Passat. Now you might think, how complicated can a case over an old car really be? That's exactly what makes these cases dangerous. Because when people come into court over something small, what they're usually really fighting about is something much bigger. Trust, pride, old history, broken friendship, and sometimes revenge. The plaintiff, Ms. Pishney, was asking for $1,500. She claims she sold her old high school acquaintance a car, they agreed on a payment plan, he took the vehicle, and never paid $1. Simple enough. At least that's what she wanted me to believe. Then I looked at the defendant. Calm, almost too calm. That usually tells me one of two things. Either someone is completely innocent, or they have convinced themselves they've done nothing wrong. He didn't look nervous. He didn't look scared. He looked comfortable. That caught my attention immediately, because innocent people are nervous in court. Liars are often relaxed. They've rehearsed, so I asked the most basic question first. How long have you known each other? Since high school? Wonderful. That means history, and history complicates facts. She tells me, I sold him a car. He says, no, she gave it to me as a gift. A gift. Now let me tell you something. Adults do not casually gift cars to people, especially not cars worth $1,500, especially not when they later sue you over it. So immediately someone was lying. The question was who? I turned back to Ms. Pishney. I asked what kind of car it was. I'm no one going to say Volkswagen Passat, old, nothing glamorous. Then I asked why she was selling it. Her answer? She wanted it as a second car, but then got her original car repaired and decided to keep that instead. Reasonable. At first, but then things began slipping. And this is where cases get interesting. Not because of evidence, because of details. Details are where lies go to die. She explained that she had only owned this Volkswagen for a short time. Apparently, she bought it from some man named Mike, who buys and sells cars. Already my radar goes up. She bought the car for $1,500, and then, only about 2 months later, decided to sell it for exactly $1,500. No profit, no loss. That's possible, but odd. Then came the first twist. I asked how the sale happened. Did he come inspect the vehicle? Did he test drive it? Did he negotiate? No. According to her, she simply called him. Not a stranger, not a Facebook buyer, an old acquaintance, and asked if he wanted to buy her Volkswagen. And according to her story, he agreed to buy it for $1,500 over the phone, without seeing it, without checking if it ran, without asking questions, without inspecting anything. And then it gets better. She says she left the title inside the car, left the keys, and he simply came over and picked everything up. That was supposedly the first time he even saw the vehicle. At that moment, I nearly laughed. Not because it was funny, because it was absurd. You expect me to believe a grown adult agreed to spend $1,500 on a 1996 Volkswagen site unseen? And not only that, but the seller handed over the title immediately before receiving even one payment? No deposit? No written agreement? Nothing. That's not a sale. That's chaos. So now the courtroom energy changes. The audience feels it. The plaintiff starts looking uncomfortable because her story is technically possible, but not believable. And in court, believable matters a lot. Then I ask the next obvious question. If you were selling this car, why would you leave the title inside it before getting paid? That's when hesitation began. And hesitation is gold. Truth is usually fast. Lies need assembly. She tried explaining that he promised to pay in installments. $750 after 2 weeks, then another $750 2 weeks later. Again, no payment up front, no signed paper, no witness, no text confirmation, nothing. Just trust over a car. Now, maybe you're listening and thinking, Judge Judy, people do dumb things. Yes, they do. But dumb doesn't automatically equal truthful. Then I turned to the defendant. And here's where the second twist arrived. He wasn't fighting aggressively. He wasn't defensive. He wasn't panicking. Instead, he behaved like someone who truly believed the car was his. That's different. A scammer usually over-explains. This man seemed confused that he was even being sued. That changed my focus. Because now this wasn't just about whether money exchanged hands. It became about intent. Did both people walk away from that exchange believing different things? That happens more than you'd think. One thinks it's a loan, one thinks it's a gift, one thinks it's temporary, one thinks it's permanent. And then 6 months later, everyone hates each other. So I dug deeper. What condition was this car actually in? And suddenly the case took another turn. The car wasn't properly running. It couldn't be registered. Now hold on, that matters a lot. Because if you're selling someone a car that can't be registered or legally driven, that changes the value entirely. And suddenly the defendant's story becomes more plausible. Why? Because nobody in their right mind buys a problematic vehicle site unseen for full asking price without paperwork. But someone might accept a junk vehicle as a favor or gift. See the difference? Now the plaintiff's original clean story was getting messy, and messy stories lose cases. I leaned back and watched. This is the moment I love most in court. Not because someone is about to lose, but because truth starts squeezing through cracks, and usually people reveal themselves. The plaintiff kept trying to force the narrative. I sold him the car, but facts weren't supporting her. No payment history, no messages, no written agreement, no receipt, nothing. And here's a legal life lesson. If you hand over property, keys, and title without payment or documentation, you are voluntarily stepping into a disaster. Court cannot repair every bad decision. It can only interpret evidence, and evidence here was weak, very weak. Then I asked myself the central question: who behaved more consistently with their story? The defendant says it was a gift. His behavior? Took the car, no payment, no urgency. Consistent. Plaintiff says it was a sale. Her behavior? Hands over title before payment, no contract, no deposit, no written proof. Inconsistent. That is devastating, because courts don't just hear words. We compare words to actions. Actions are louder, always. Then came another subtle twist. Her timeline kept wobbling. Dates became uncertain. First 2015, then maybe 2014. Small thing? No, not in court. When money is involved, dates matter. People remember financial transactions better than casual memories. So uncertainty chips away credibility. Not destroys it instantly, but weakens it. And by now, her credibility had taken several hits. The audience could feel the shift. Cases are often decided long before the final ruling. Not legally, psychologically. Once a story collapses under simple questioning, rebuilding it is nearly impossible. And that's exactly what was happening. This wasn't about a stolen vehicle anymore. This was about an informal arrangement between two people who never bothered to clarify terms, and now one wanted court to clean up the mess. That almost never ends well, because courts require proof, not vibes, not assumptions, not "he knew what I meant" proof. I looked directly at both parties, two adults, known each other since high school, a car exchanged, a friendship, or whatever remained of it, clearly destroyed, over $1,500, or maybe over principle. Sometimes people sue because of money. Sometimes they sue because they feel disrespected. And honestly, this case smelled more like wounded pride. She may have believed she'd eventually get paid. Maybe casually, maybe informally. But belief is not contract. Expectation is not evidence. And emotion is not documentation. That is a brutal lesson many people learn too late. If you are selling something, get it in writing. Get payment terms documented. Do not hand over title before payment. Do not assume friendship replaces paperwork. Friendship disappears very quickly when money enters the room. And in this courtroom, I see that every day. By now, I had heard enough. The facts were simple. The evidence was weak. The plaintiff had the burden of proof, and she did not meet it, not even close. You cannot walk into court, tell an improbable story unsupported by documentation, and expect judgment in your favor. Not here. Not with me. Because court is not a place for retroactive organization. You do not get to behave recklessly and then ask the legal system to save you from your own choices. That's harsh, but true. And truth is what matters, not feelings. So as I looked down at the file one final time, the outcome was clear. This case had started as a simple unpaid car dispute, but underneath it was a far more common story. Two people with vague verbal expectations, zero documentation, and completely different understandings. That is a recipe for disaster. Every time, and as I prepared to rule, I could already see it on their faces. One person hoping emotion would outweigh evidence, the other knowing silence was working in his favor. Court doesn't reward louder stories. It rewards stronger proof. That day, one lesson became painfully expensive. Sometimes losing $2,500 is cheaper than learning how costly bad decisions can become. Judgment for the defendant. Case dismissed.